Talks, a podcast designed to support people going through a relationship breakdown and all of the challenges this brings. I'm Matthew Taylor.
And I'm Lisa Gatchell, family lawyers at Stowe Family Law, and today we are delighted to welcome divorce consultant Rhiannon Ford to the podcast to share her advice on how to prepare for a family court hearing. So welcome Rhiannon, thank you so much for joining us today. Can you start just by introducing yourself and letting our listeners know a little bit about you?
Sure, thanks Lisa. So I'm a divorce consultant and coach. I've been doing family law work for about 25 years. My background is I was actually a family law solicitor myself, but I left private practice and I've been running my consultancy service for, it'll be 15 years actually in July. And my role, as I see it, complements that provided by the solicitor. So I provide sort of help with the non-legal issues. So the solicitor's there to provide the legal representation and legal advice. And hopefully what I can do is some hand-holding, practical help, but also helping with sort of those difficult emotions and mindsets as well.
Yeah, so let's start there maybe with the emotions and mindsets, because we're here to talk about preparation for a family court hearing, which is one of the most stressful things I can envisage anyone having to go through. There's obviously lots of different types of hearings, and perhaps we'll get into the nitty-gritty of the specific hearings in a little bit. But maybe let's start with when you get a client, Rhiannon, who is saying to you, "Oh my God, I've got this hearing. What's the mindset? Where are they at? What are they thinking?"
I think, as you've described, I think it can be sort of very daunting for clients. They feel very apprehensive. I think the big challenge for people is the unknown. So that uncertainty. They've never had to go to court before. Their experience of how courts run often comes from watching TV. And obviously, as we all know, the actual reality is very, very different. So I think they can be, I think the uncertainty is the biggest concern that they have. So what I always find is really important is making sure people feel informed so that they understand exactly what's going to happen at that particular hearing, or as much guidance as we can give. Obviously, the judge makes the decisions, but for them to feel informed, I think, takes away some of that apprehension. And then making sure, and I've got different sort of things that I do with clients to make sure that their mindset is as good as it can be in what can obviously be a stressful situation, and sort of helping them in sort of controlling those difficult emotions as well.
There are, as you said, there's lots of different types of court hearings. I wonder whether it would help if we started by sort of running through those. And I'm guessing there's sort of different preparation, or I know there's different preparation that's required for each of the different types of hearings. So, let's start with the first type, which, whether you're in children's proceedings or financial proceedings, tends to be a directions appointment. So if you're in children's proceedings, it will be a first hearing dispute resolution appointment. And if you're in finance proceedings, it will be a first appointment. How would you start by helping somebody to prepare for these types of hearings?
The first thing I tend to tell people is in the first hearing, you won't actually have to do anything yourself if you have legal representation. So if you have a solicitor and a barrister, the client won't need to speak. And I think that's their biggest worry is, oh my goodness, I'm going to have to speak. What am I going to say? What's going on? So the big thing is that I always say is you don't have to say anything. You just have to be there in body. So that they just have to sit there and listen to everything that's going on. So I think that's the big thing. The other thing then, as I mentioned earlier, is making sure they feel informed about what's likely to happen and also what the likely outcome will be of that particular hearing. So the way I sort of describe the first hearing in either children or financial proceedings is it's sort of introducing the judge to the case. So it's sort of like more housekeeping than anything else. It's introducing the case, explaining who the parties are, what's going to be happening, and then at the end of the hearing, the judge will decide what the next steps need to be. And if the client has good understanding of that's what's going to happen, I think that can alleviate quite a lot of their stress.
Yeah, I think that's right. I think they need to understand it. And look, there's a lot of terminology and there's a lot of misconceptions and things, and the more that you can explain things to clients, the better. The way I describe the first hearing is that the question for the judge at the first hearing is, what information do we need to determine these proceedings? So do we need statements? Do we need disclosure? Do we need evaluation? Do we need a letter from the school if it's something related to children? So I think having that in the front of the mind can be really useful. I think the the not being able to, that's the very first thing is, oh, do I have to speak? That's always a client's first concern. And obviously you get some clients who are desperate to speak, and when you say to them, you're not speaking, that can be a bit challenging. Do you have to, in the nicest possible way, rein people in a little bit as well?
Yes, sometimes. Sometimes clients are quite enthusiastic, shall we say,
Yes.
about their case and getting their point across to the judge. And understandably, they feel that they're in the best position to provide information about their own life, their own marriage, children, finances. And it's important when people are legally represented. I always say, look, have faith in your legal team. They've got your back. They know your case. They have the best way of explaining to the judge. So let them, they're the experts in how to present your case. Your time will come if it goes all the way to a final hearing, but you're working together as a team, but your lawyers are your advocates, your voice pieces. So you've got to keep quiet.
Yeah, easier said than done. And it's not just about keeping quiet as well, because you're going to sit there and you're going to hear your spouse or ex-partner or whoever's legal team saying some stuff that frankly you're probably not going to love. And there's a lot in kind of body language, tutting, eye rolling, facial reactions that can be quite challenging to control, can't it?
Absolutely. So I was working with a client on Friday to do some court preparation training with her, and she was actually going to be going to a hearing where she would be answering questions. So we're obviously focusing first of all on the first hearing. But I did explain to her that as well as sort of helping her with what she's going to be saying and how best to present her case when she's asked questions, we also needed to think about her being on best behavior when the other side are talking. So as Matt, as you said, the other side are going to be, the other side being obviously your ex's legal representation, they're going to be saying things that you're probably not going to like, you're going to feel uncomfortable, that are going to trigger you. And what the first thing I always say to clients is, anything that the other side are going to say is not going to come as a surprise because we know their case. We know what they're going to say. So don't allow yourself, as much, I know difficult obviously, to get upset when they're saying things that you think, oh, here we go again. They're saying things that I don't agree with or are not correct. So that's the first thing is actually, and that can help people to sort of keep control, shall we say, of those difficult emotions. And also then the other thing I always say to people is you are on display in that court hearing. So the judge will be looking at you when people are speaking. So you've got to avoid shaking your head, tutting, sighing, showing any emotion. The easiest way around it, I always think, is to put your head down, pretend you're sort of doodling or writing notes on a piece of paper so that the judge doesn't see your face. If you are one of those people that has a particularly expressive face, shall we say, when you're hearing information. So I think those are the two main things I tend to go through with people because it's so important to keep control of those emotions because the judge is looking at you the whole time and obviously they're the most important person in that room.
I think the other thing with the initial appointments in particular as well is that clients sometimes they want to give, as you say, give everything to the judge, let the judge know exactly, the ins and outs of every little detail. But the reality is that the judge you've got at that first appointment isn't necessarily going to be the same judge that you're going to get at the second hearing or the third hearing. And so actually that's why sometimes it can feel like, well, I've told my solicitors X, Y, and Z, and they're not responding to each and every point that's being raised. But it's actually what we're trying to do is narrow the issues at this hearing, and those points are ones that are probably for hearings further down the line.
Yes, absolutely. There's a time and a place, isn't there, for presenting the client's case?
Yeah, absolutely. So if we move on then to the second hearing. So this hearing, whether we're in children or financial proceedings, is a little bit different, takes a little bit longer. Again, the client won't necessarily be asked any specific questions. We're not talking about cross-examination. We're talking about a dispute resolution appointment for children's proceedings or a financial dispute resolution appointment for finance proceedings. And these hearings are a little bit longer. They require both parties to say what they want to the judge effectively, so to give their case, and the judge will then give some guidance, if you like, as to what they think should happen in these types of circumstances. How do you prep clients for these types of hearings?
The first thing is that I always make sure that the client understands that it's probably going to be a very long day. So it will be a day of negotiating. And so they need to be prepared for that sort of mentally, emotionally, and on a practical basis. So making sure that they've got the practical things arranged. So, for example, childcare arrangements, so they're not worrying about pickups from school, etc. And also making sure that I always think that practical prep can really help alleviate mental stress. So the practical things that I go through with clients is making sure they know how to get to the court, the timings, when are they meeting their legal team, travel arrangements, are they going by train, getting their tickets in advance, or if they're driving, making sure that they know where the nearest car park is, and if it's on an app. I know it sounds really silly, but it can be very stressful these days when you get to a car park and you think, oh, I've not got any change or I've not got the right app. So I think getting informed about what to expect and preparing on a practical basis can make a big difference. The fact that it is a very long day, some other bits and pieces that I go through with clients is make sure you get a really good night's sleep the night before. Don't drink too many glasses of wine so that you're waking up with a fuzzy head. You want to have a clear head. You want to feel fresh. And I think, making sure then that you've asked your lawyers everything that you feel you need to know so that you can prepare can make a big difference as well. And a big thing that I always go through is because it's a long day, depending where the hearing is. So you're okay if it's a private hearing and it's going to be in barristers' chambers. Barristers' chambers are pretty good with snacks and sorting out lunch and all that sort of thing. But if you're in a court building, the courts are not really set up very well for if you need to have drinks and snacks. And it's really important to keep yourself fueled and hydrated during the course of the day, because you want to put yourself in the best position possible to be able to be thinking clearly to make these really important decisions. So I'm a big one for taking snacks. So there's a few solicitors I work with, and I'm well known for bringing plenty of chocolate and nuts and things like that, making sure the clients have got drinks and that sort of thing. And I think that can make quite a big difference, really, to make sure that the client feels as comfortable as possible when it can be a really tough day, not just for the client but the lawyers as well. It's a long day for everybody normally.
Yeah, I mean, it can be, a full sort of 9 to 5 of constant negotiating, in and out, seeing the judge. These are quite flexible days, particularly FDRs, the finances. You can nip in, see the judge for an hour, make your submissions, come back out, go back to clarify a point. Judge might ask for an update. And I spend half the day playing mum. Do you want a cup of tea? Can I get you a sandwich? What are we doing? It's really important. And most of my clients, don't sleep that well the night before because of the stress. And then, I couldn't possibly eat. And you can see people flagging because you need the energy. I think that with these hearings, because these are not hearings where a judge is going to tell you the answer. The judge is going to give an indication, a guidance, like Lisa said, and then it's up to the parties to either settle or not. And most cases do settle around these. So I think something really important that I always speak to client about is knowing where you're going in with your position, saying, let's say your case is it's a 60-40 split to you in the finances, your case. That might be your opening position, but I think, in most cases, you're not making it. Sometimes I do actually make your opening position, you're hard and fast, we're not moving from this, if it's just very clearly the right answer. But a lot of the time, you need to have a backstop. So you need to be clear on what are your red lines? What's the worst case scenario? How far will you go? I mean, is that something that you talk about with clients, Rhiannon?
Yeah, absolutely. I think it's really important for clients to know, as you say, it's a day of negotiating. The judge won't make a final decision. They can approve an agreement, but the big thing that the client needs to think about is they need to go in with a negotiating mindset. So they've got to have that flexibility and be open-minded to reach an agreement. And absolutely, I go through with clients, what are your legal positions that your legal team are putting forward? What's your best case scenario? What's your worst case scenario? What would you settle for? And, I think in family law, we always like to think about, there aren't winners and losers in these cases. It's all about compromise. And actually, chances are that both parties, if an agreement is reached, are going to come out not necessarily 100% happy with everything, but at least they've got a deal, and actually that's the most important thing. So I think it's really important for people not to become too steadfast in this is my position and I'm not budging, because actually they're not going to get very far in the settlement hearings, in the negotiations, and that's not helpful for them either. They've got to keep an open mind to be able to be flexible, to negotiate properly, and often it is all about compromise.
Yeah, I think that's really important. I always say to clients that it's about finding an agreement that you can stomach, draw a line under, and move on from. Is far more important than feeling that you've won. And actually, if either party comes away thinking that they've won, you've probably not got a great agreement there. That's not what we're looking for. We're looking for having something that is fair. And usually for fairness, there's going to be a degree of compromise on both sides. And so it might feel a little bit uncomfortable. Okay, should we move on to the last hearing then? So this is a final hearing. So this is the hearing at which the judge will make a decision, and cross-examination is going to be required. And I think this is the hearing that clients get most nervous about. They're probably the hearings that are least common as well, because most of the time we do settle cases before these types of hearings. But how does the prep in relation to a final hearing differ from that of the two hearings that we've spoken about before?
So yeah, this is the biggie. This is the big one that is going to probably, as you say, make the clients feel most nervous. And the reason being is because at this hearing, they will be asked to speak. So they will be asked to answer questions about their case. And so one of the services that I provide is what's called formally witness familiarisation training, or what I call court prep to clients, because it's a bit more user-friendly phrase. And even though clients get very nervous about providing answers, the way I try and present it to them, actually, this is a great opportunity for them, because what it's doing is it's bringing the case alive to the judge. Up until that point, the judge has had the written documentation, the written case, if you like, that the solicitor has prepared, and the barrister has obviously introduced the case and been the advocate so far. But the client's role in the final hearing is really important, because the main part of a final hearing is the giving of what we call oral evidence, which is when the parties themselves are answering questions. That's the main part of a final hearing, and it can be really influential to the judge's decision making. So how a client answers a question goes to credibility. You know, are they reliable? Is the judge going to believe what they say? Are they being authentic? So it's really important, I think, that the client feels as comfortable as possible about answering questions. The big thing that I think is the most important aspect of answering questions at a final hearing is to only answer the question that you're asked. And it sounds really, really obvious, but what tends to happen is the client is so enthusiastic about making sure that the judge has all the information that he or she requires that the temptation is to ramble on for far too long. And the risk there is that the actual crux of the answer that the client is giving gets sort of diluted in the rambling, and the judge then may miss that important point. And we've got to remember that we want to spoon feed the judge with the information that we want them to have for them to make the best decision possible. And so what I always say to clients is, listen to the question, pause, think about what is this question asking me, and then think about how you can answer that question with a clear, concise answer. So I tend to advise people, see if you can answer the question in just one sentence, or at most 2 sentences. And some clients look at me as if, well, I've got a lot more to say. I'm never going to do this in like 1 sentence. And what I tend to say is let the barristers do the work. If they want more information, if they feel that you need to be providing more information, they'll ask you another question. They've prepared what questions they're going to ask. Let them do the work. That's what they're getting paid the big bucks for. Let them ask the next question. That's not your responsibility. Just answer in a clear, concise way, and always make sure you're focused on the judge. That's obviously the most important person in that room.
Yeah, that's really great advice, and I think part of that is also knowing it's really important to know when to stop talking. And if you're giving witness evidence and you stop talking, often the barrister will not say anything and there'll be a pause. And that might either be deliberate or they might just be checking their notes or just taking a little bit of time themselves. And pauses and silences are really uncomfortable. And a lot of witnesses feel the need to fill that silence. And then you end up over talking and you carry on, you go off at tangents, and you can see a judge getting confused and getting a bit annoyed. And so just being, it's really uncomfortable, but just going, okay, I've said what I've said. I need to stay quiet now. If you've not said enough, the barrister will tell you, you can be sure. I mean, that's absolutely right. But I think that, silence can be a weapon in evidence giving sessions.
It's really
Absolutely.
hard.
Yeah, it's really hard.
Yeah.
I wouldn't be very good at it.
No, I'm awful at it. We do, but when we talk about it in relation to feedback, I'm really rubbish at holding silence. And also, there is this, the worry is then you give too much as well, or you trip yourself up a little bit. So yeah, like keeping it short and concise is really important, but really, really difficult.
Absolutely. It's very difficult. And, as Matt said, it's good to remind the client just to leave that silence. And sometimes the nerves can get carried away, or I'd find it really difficult. It's do as I say, not as I do.
And when you're actually working with clients on that, is it something like, it's really tricky. I think maybe let's get sort of into the weeds a little bit. It's hard to prep clients for final hearings because what we can't do as lawyers, and what you won't be able to do, is tell clients what to say. It's their evidence. There are strict rules against it. Your clients will say to us, if I'm asked this, what do I say? And we have to say, well, look, I can't tell you that. It's your evidence. But you might want to have a look back in your statement about what you've said. What are you give your recollection and give your honest view. So it can be quite tricky, I think, to tread the line between getting clients familiar, getting clients comfortable as they can be, but also you can't direct the evidence. How do you kind of thread that needle?
Yeah, it can be tricky. As you said, Matt, it's really important as divorce professionals that we're not telling our clients what to say. There are special rules in place, as we know. And yes, I do often get asked, oh, should I say this or should I not say this? And I just have to say, you've got to be truthful. You've got, even if what you need to say to be truthful, you think, oh, I'm not sure that's going to go in my favour. It's more important to be truthful. The judge is going to appreciate that much more, knowing that, so sometimes clients have said, well, if I say, that I regret that I said that or did that, but I'm telling the truth. Is that okay? And I said, well, if you're telling the truth, then you can't be criticised for that. But it can be really difficult for people because they do worry about being tripped up in being asked sort of what I call stinky questions. And it can be quite difficult. So when I am advising people and helping them in sort of preparing how to answer questions, I focus more on the style, so talking slightly slowly, making sure you're focused on looking at the judge, as we've talked about before, listening very carefully to what the question is. If you need more time to think about your answer, taking a pause, taking a glass of water, asking for the question to be repeated, just to give yourself that little bit of space to think about what you want to say as your answer. But I think being truthful is the most important thing. And I always make sure that the clients know that they haven't been referred to me because I'm the one that can tell them what to say. I can't do that. It's got to be real. It's got to be authentic. It's got to be their evidence. And actually, that's really important. And the judge wants to hear from them. And sometimes we're only human. Sometimes answering a question may not fully support our case, but it's more important to be truthful.
I think that's really useful. And I think obviously prepping someone for a hearing is more about prepping them for style over prepping them for content. Often it's, how do they say what they're going to say is the stuff that we can really help them with. So loads of useful advice there, Rhiannon. Thank you so much. I wonder if we can just finish with your 3 top tips for anyone who's listening to this thinking they've got court proceedings either ongoing or incoming. What would be your 3 top tips to get ready for a family court hearing?
I think the first one would be to get informed so that you've got realistic expectations of what's likely to happen at the particular hearing that you're going to. So if you're legally represented, obviously you ask your solicitor, what's the purpose of this hearing? What will be expected of me? What will the lawyers do? What's the likely outcome? I think that can really help alleviate the worries of that uncertainty and the nerves as well for clients. So I think that's a big thing, so that they've got realistic expectations. I think the next thing I would say, so tip number 2 would be practical prep. So I think practical preparation can help with the mental stress. So feeling like you've done, so it's a bit like taking control of the controllables. What can I do on a practical basis to help myself feel better? So that's, finding out where the court is, making sure you know the timings, travel arrangements, childcare, making sure you've got plenty of snacks, that sort of thing. Making sure you go to bed early the night before, etc. And actually that leads on to probably my third tip, which would be self-care. So making sure, this is a really stressful time in your life. We understand that as professionals, and you want to put yourself in the best position possible for managing and coping with whichever court hearing you're going to. So making sure you're getting plenty of sleep, making sure you're getting fresh air and exercise, and just looking after yourself generally. And part of that as well is having the right support system in place. So obviously your lawyers are part of that. They can help with the legal representation, your legal case, but also friends and family can be a great support. And also obviously working with people such as myself to get that sort of extra help and support can hopefully make quite a difference as well. So yeah, I would say those are probably my 3. See, I can't do things in like one sentence, so it's very much do as I say, not as I do when it comes to giving evidence in court. But yeah, I think those are probably my top 3.
Well, I think anyone who's listened to these podcasts would know that me talking quickly or shortly or shutting up at any point in time is never going to happen. So I can completely empathise with that.
It's a struggle. We all try. Thank you so much, Rhiannon, for joining us. It's been a really great episode. So that's it for this episode of Stowe Talks. Thanks for listening. You can find out more about the work Rhiannon does supporting clients at www.rhiannonford.co.uk. If you would like more information on our podcast, then head over to stowtalks.co.uk, and please rate, like, share and review this podcast where you can.